Yeah, they're both in jail. Rogers is a plea. The other guy, I think, is gonna. Well, we're kind of trying to figure out what's happening, but probably is running. I guess let's say that's what it's.
Got it.
Oh,
Yeah,
got
pretty
it.
much everybody's in jail or represented by Mr. Lee, who's not here. Got it.
Is there something I can do to help with Mr. Lee?
I don't know you guys can still.
Okay.
He's apparently before Judge Kennedy or something right now.
Oh,
I don't know.
okay.
But he's got five cases here today.
Judge, let me look on my calendar and see if there's anything I can help with. But
Thank you. I know he had something set for a plea. Savannah Lewis, is she here? Maybe that, if they have that all worked out, maybe they can do that one.
Sure. Oh, let me get it out of the way. I'm sorry. Yeah.
Ready?
Yes.
Okay, this is the matter of the state of Michigan versus Joseph Cena, 25-02330. Appearance, please.
Thank you, Your Honor. Cassidy Kachuka for the people appearing requesting permission to practice pursuant to MCR 8.120 with Abigail Tepper as my supervising attorney.
Now, Fred Blackman, they have Mr. Simmons, he's sitting right up for them.
They say was the date that was scheduled for preliminary examination, but I said we would treat it as another probable cause conference because you had recently been retained and they just signed a substitution of counsel.
Thank you.
How are we proceeding on this matter?
Unconditionally waived, Judge. I think negotiations are ongoing and be resolved in circuit court.
That's my understanding as well, Your Honor.
Yeah, because my computer just shut off the record. Jesus. I heard it click. Did it go back on? Your computer's gonna, okay. This poor building. Oh, okay. That was easy for me. And hopefully yours is easy too. Well, I guess you want to find this while we work. Wait.
I'm so sorry.
It's fine.
I have to sign that. Oh, I forgot.
You need
I
for
forgot
that.
it's still-
You are a baby. It's fine, you'll be fine.
Yes. In theory.
So bossy, Fred.
This mess. What's it?
Beyond our control. No, almost
Well,
entirely.
you're shutting off is beyond my control.
Yeah, we're on.
Okay, back on the record. Let's see, is the prosecutor going to waive exam as well?
Yes, Your Honor, the people will unconditionally waive our right to preliminary examination at this time for ongoing negotiations in circuit court.
Thank you. Okay, so Mr. Sina, you understand that you do have the right in this matter to hold a preliminary examination in the district court.
Yes, sir.
You understand that you have the right to have the prosecutor at first establish as to count 1 and count 2, that there was probable cause sufficient that these felonies were committed and then sufficient probable cause to charge you as the person who committed those felonies.
Yes, sir.
And you want to unconditionally waive your exam?
Yes, sir.
And you understand that if you get to the circuit court and negotiations don't go well, you don't get to come back and have your exam. You understand that?
Yes, sir.
Anyone threatening you to get you to waive exam, sir? Find your waiver to be freely and voluntarily given. The bind over date is gonna be September 10th. That is the date the circuit court needs to file from the district court, not the date you need to appear in circuit court, okay? Your next court date is going to be a pretrial. Mr. Blackman will be made aware of that, okay? You have any questions for the court? Bond was set at 3,010%, and that will continue. Any additional matters for the record?
Not this week, Your Honor.
Not from the transcript.
Thank you.
Right.
Apparently, Miss Jones, apparently Aaron Rodgers is in custody, so we need him brought up.
Aaron Rodgers?
Yes.
He's the guy with all the face. He's pretty.
She'll be right back.
Is Ms. Wanji covering for someone? Okay.
Guys, have a good one.
Have a good one, Ms. Wanji. Oh, I do see Ms. Wanji, she's on rush. Not, and then Mr. Freeman is here. Everybody's in there. Ms. Wanji,
Yeah, I am. I'm scrolling for it. Thank you. Sorry.
the mics are off? Oh, boy.
Yep, the one you're on.
Still?
5,000.
Should I get Anithia? Yeah. let's see. Charles Davis here. And Savannah Lewis, I believe, is here talking to Mr. Connor.
Correct.
And then Travis Driggs is in custody. We've not seen Jumataro soon. We had contact with that individual.
I do not believe I have, Your Honor. I had attempted, I'll pull up my notes right now. Certain that the number that we had on file belonged to a young lady who advised that she was no longer in contact.
What's the last four digits of the number that you have?
7070.
He was arraigned on the 11th. We got a new number for him,
Yes,
5764.
no, the number we have is 517-345-7070. He called the, I'm sorry, that's the number we have on our file.
Okay, I can give you the new number. I don't know if you can call him.
That would be great.
So I don't have an address.
517 is the area code. 528 5764.
I'll do that
The
right
misdemeanor,
away.
yeah.
You can be seated.
Judge, I do have plea documents if I may approach.
You're on the record in the matter of the state of Michigan versus Aaron Rodgers, 25-02424, appearance. Please.
Thank you, Your Honor. Cassidy Kachukis for the people.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Rogers, who stands for my right.
Mr. Rogers was scheduled for preliminary examination today on a controlled substance possession, and there's an offer for him to plead guilty to an added count 2 of use of a controlled substance, dismissing count 1. No objection to sentencing under 7411, correct?
That is my understanding, Your Honor. Yes.
That's it.
And you want to accept that offer, sir? Raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury.
You have to say it out loud.
Yeah,
That's a yes?
yes.
You can put your hand down.
He's hard of hearing, Judge.
No worries.
40% death of both ears.
Okay, do you need a device? Do I have a device anymore? It may not
It's all
work.
good. I
No
can
worries.
hear.
Okay, sounds good. Okay, and so I have an advice of rights and plea information sheet. Did you go over this with your attorney?
I sure did.
Okay, and you understand the rights here?
Yep.
Do you want to waive these rights today? That means give the rights up so that you can enter a guilty plea.
Being guilty for the charge of the misdemeanor.
I can get it, Judge. Mr. Rogers, we talked about how you have all these trial rights, like the right to remain silent, all those kind of things, right? Is that a yes?
Yep.
All right, and you understand that if you enter a guilty plea today, to enter a guilty plea, you have to give up those rights like we talked about. And then in return, you're allowed to enter a guilty plea.
Okay,
And that's what you want to do today?
sure.
Yeah.
These rights, you want to waive them so that you can enter a guilty plea?
Mhm.
Is that a yes?
Yes,
Okay, so that means you're gonna give up your right to the presumption that you are innocent. You understand that, right?
Mhm.
Is that a yes?
yes,
Okay, that comes with the right to proceed to trial and require the prosecutor prove your guilt beyond a reasonable doubt. Your right to call witnesses that can testify on your behalf, your right to remain silent, not have silence be used against you, and then your right to see, hear, or question any witness the prosecutor calls to testify against you. You understand each of those rights?
yes.
Is anyone threatening you to get you to give these rights up?
Nope.
Has there been any coercion or promise to get you to give these rights up? And are you looking to plead guilty to the amended charge because you believe you're guilty?
I'm guilty.
Okay, okay, factual basis.
Thank you. Mr. Rogers, I'm going to take you back to August 11th of this year. On that date, were you at or near the intersection of South Holmes Street and Gray Street in the city of Lansing?
Yes,
And you came into contact with some police?
yes,
And at that time, you were in possession of methamphetamine?
yes,
And you had that methamphetamine because you used methamphetamine or intended to use it?
yes.
All right. And you don't have any legal justification to have methamphetamine, is that right?
Nope.
I think that satisfies factual basis, Your Honor.
Any questions from the prosecution?
No, Your Honor.
Court satisfied with the factual basis and find your plea be freely, voluntarily, and intelligently made. Sentencing is scheduled for October 30th at 9 a.m.
Judge, could I address bond?
Get just a moment.
Sure.
You're gonna need to meet with probation so that they can advise the court of how you should be sentenced. So you're gonna meet with them. They're gonna schedule you for a pre-sentence interview. I'm also ordering that you undergo a substance abuse or substance use assessment, okay?
Okay.
This bond was 510%. Is he being held on anything else?
No, Your Honor.
Okay. The address bond.
Oh, thank you. Judge, I would ask that the court consider a personal recognizance bond for Mr. Rogers. I know he's been sitting in custody for a couple of weeks at this point. Certainly, Mr. Rogers is homeless. He's struggling a little bit, but he does have some plans to turn that around. He intends to stay at a shelter in the short term if released. He does have a friend who's kind of got him lined up with a job at McDonald's. Also, I think Mr. Rogers wants to get out so he can continue to be a support system for his 9-year-old daughter who lives here in Lansing. I will say, I have also provided Mr. Rogers with my telephone number and email address. I've advised Mr. Rogers that if released, he should contact me. Our office does have social workers who I've already spoken to about Mr. Rogers' case with our plans to try to get Mr. Rogers into more stable, I guess, longer term shelters, something like Loaves and Fishes or something along that line. So that Mr. Rogers can start getting access to a number of services, employment services, housing, medical services, and those kinds of things. So I would ask that the court consider a personal recognizance bond. I recognize that he's being held on a very low bond already, but at this point, any bond is virtually, is too much for Mr. Rogers. He just doesn't have any money because he's not working. He's been suffering from homelessness. I would also point out, Judge, he has a very limited criminal history as far as I can tell.
Your Honor, as far as the people go, I do not see any criminal history at all. I will leave it to your discretion on this one.
I think the concern I have is we don't have any way of getting in contact with him. We don't have a phone number. We don't have an
I mean,
address.
I could give you my grandma's number. I keep in contact with her all the time, and she's actually watching right now.
How do you keep in contact with her?
I can give you her number. It's 517-5.
No, I'm asking you, how do you keep in contact with her if you don't have a
Oh,
phone?
I show up to her house. I was literally a block away from her when I got arrested.
Judge, the other thing, my understanding, and from conversations with Mr. Rogers privately, is that he has a text now number, so he does have a cell phone. He just doesn't know what his cell phone is.
Okay.
You know, I also share the same concern because I like to keep in touch with my clients and make sure they are aware of their court dates and that kind of thing. Part of the reason I provided him with my telephone number and email is so that I've asked him to contact me if he's released, to contact me immediately so that as soon as he gets released, as I understand that text now phone number or phone is in his property. He just doesn't know the number off the top of his head. It has limited minutes on it. Those minutes are set to reset here in the 1st of September. So I do think, and Mr. Rogers has promised to contact me. So I'm hopeful that he will follow through on that and that we will have a working number that we can call him at once he's released.
Okay, so you say you are not gonna be staying with your grandmother, but you stay in contact with your grandmother. That's yes.
I do stay in
Okay.
contact.
And she lives in Lansing.
Yes.
Do you believe she's watching today?
Could be. Yeah.
Okay. And then when's your next court date?
It said on the piece of paper, it said something like the 9th of the next month.
Actually, Judge, he technically, I think he's correct. He's got a City of Lansing case that's also before Your Honor. And
That's important.
and it's set for September 9th. So he's technically correct.
That's your next court date then. It's yes, it's subsidy of Lansing. I do see it. Or the 9th or something.
Glad you
There's
got
that.
I don't have that.
He told me yesterday when I met with him in preparation for today, he told me yesterday when his next court date was, and I looked at it and he was absolutely right. It's a knife over 3 inches.
Oh, yeah.
From
Yeah.
the same date.
I think so.
No, because
no.
there was a warrant for it the same date.
Right.
Yeah, I just looked at the affidavit of probable cause. It said something about a sheath in the pocket, so that's why I assumed it's from the same.
I'm not sure.
Over
It's with
three
the-
inches.
It's with the City of Lansing. But yes, September 9th is his
From the
next
same
court.
date.
So
Yeah, the same set of facts. Your attorney should negotiate a go over resolution.
I'm very
No,
observant.
it's a
It
City of
is a
Lansing.
separate date, Your Honor. I believe in our report, we have that there was a knife on scene that was over 3 inches, but that there was a warrant as well for a knife over 3 inches. But I
From
think
a
there,
different,
Yeah.
It was the
I believe
same, it
there
was
are
the
two
same
separate
exact knife I bought it from Walmart.
I'm not, we don't know, we don't know
Don't
anything about what you're talking about, okay? We don't know anything about the knife. You have the right to remain silent. Anything you say can be used against you. You're saying that the knife over 3 inches is not from August 11th.
that is my understanding, Your Honor,
I
because
can-
in the report, it does say that there was a warrant already out for it, and I don't think we can have a warrant out for it if
Judge, I'll tell you in just.
From June 18th, 25. It's a different incident.
Yeah.
Got it. Okay, sounds good. So what we can do is I will amend your bond because you're at least showing me that you're keeping up with your court dates. you need to report to probation within 48 hours of your release in person. And that is to make sure they schedule you for your pre-sentence interview and make you aware of how you can get your substance abuse assessment, okay?
Okay.
And then you'll have to report for your sentencing, which is currently scheduled for October 30th, okay? And I think you're gonna get, if you haven't yet, a notice for that, with that date on it.
All right.
Do you have any questions at this time?
Nope.
We have an email for you. Go figure 122. Is that you?
Yeah.
Okay.
Or
and you check-
AR-15 at its best at iCloud.com. That's another one you could get at.
Well, we like the go figure one. We'll use that one.
Okay.
Okay. And so, you remain in contact with your attorney, because if things change, your attorney is the one who's gonna get that information. So if he can't find you or get in contact with you, you could, anything could happen, your court date could get switched, anything, and we need to be able to get in contact with you, okay? Do you have any questions at this time?
Nope.
All other bond conditions will continue. We'll see you at your sentencing. Don't forget to come and see our probation department no later than Tuesday, because Monday's a holiday, okay? You're all set.
Just want to bring anybody.
I will.
Yeah, because everybody's in custody.
Yeah.
With Ms. Wanji's, are we running rush?
No, Your Honor, that will be a waiver, is my understanding.
We can bring rush out.
This guy's gonna take it. He's gonna take it down to there, okay?
Miss, oh, I don't see Mr. Lee. Talk to Mr. Lee. Yes, every-
Step in the hallway, hallway.
On the record, in the matter of the state of Michigan versus Jumar Terrasoon, 25-01317, appearance, please.
Sorry, Cassidy, could you just repeat, Your Honor?
Assistant Public Defender John Lee on behalf of Jumer Terrace.
Okay, Mr. Lee, I know you told me previously that you were not in contact with Mr. Terrasoon. We just provide you with information that we had in the file from the time that he was arraigned on the previous bench warrant. Were you able to make contact?
I called the number provided by the court. A gentleman answered the phone, said that Jumer was not there. Didn't know exactly where he was at, possibly on his way to court, he said, so.
Oh, okay. Well, if he was supposed to be here at 8:30, it's currently 10:02. I'll issue a bench warrant. I'll hold it until noon.
Can I discuss witnesses on that?
You absolutely can.
Thank
Okay, and then on the record in the matter of the state of Michigan versus, let's see, Savannah Lewis, 25-01954, appearance, please.
Cassidy, could you just repeat, Your Honor?
Assistant Public Defender John Lee on behalf of Savannah Lewis.
Yes, Savannah Lewis was supposed to be here for a plea today. The offer was for her to plead guilty to a malicious destruction of property, 200 to 1,000. The restitution amount was unclear at the time that the offer was given. Do we have clarity on restitution at this point?
Yes, Your Honor, I can pull it up right now. It's $5,195.03.
5,195.03.
That is correct, Your Honor. Yes.
So it's $5,195 for restitution.
Yes, Your Honor.
You were aware of that, Mr. Lee?
Yes, Your Honor. Our only request in regards to restitution is that if we could have some sort of a restitution hearing on or about a sentencing. We don't have all the proofs yet on this sentencing. We're kind of taking the prosecutor's word on repairs to the home and such. We do have a repair estimate in regard to the auto damages.
Your Honor, that's not entirely accurate. The proofs that the defense has is the same proofs that I have. I'm sorry,
Which include what?
which include the estimate for the auto damage, and the victim has assessed what is damaged and has taken screenshots of what she would need to repair it. She would have to repair it herself because
You
she
mean
doesn't
to the-
have the money.
To the property?
Yes,
like,
to the home.
Okay. Okay, I recognize there's an estimate for, you said some damage to an auto?
Yes, the damage to an auto is is 4,889 of that restitution, and the damage to the house is
Then there's,
305.94 cents.
you're saying that that's not going through insurance?
No, it is not, Your Honor.
Okay, so it's got out-of-pocket expense, the full 4,000?
That is correct.
Okay, and you want a hearing on that? Okay, we can set it for a hearing. But your client still wants to plead
Yes, Your Honor.
at this time? Okay. Do we have an advice of rights?
Your Honor, that was not really what the agreement is. The agreement was that we had agreed to restitution.
Well, we couldn't agree to restitution because it was unclear.
Yeah, I'm not clear on the, specifically on the repairs to the home. I understand that the complaining witness says she needs repairs to the home. I haven't seen any receipts or anything to that effect, is all I'm saying.
You want this defendant to plead guilty with the understanding to pay restitution without getting any clarity as to the amount of the restitution.
Your Honor, the amount that we have, the breakdown that we have for the damage to the house is from, it's been provided in discovery.
We're
It's-
not talking about the amount, but the clarity does also include how we came to that amount.
Yes, and I believe the report describes what the damage actually was to the home, if I can double check.
I mean, what we could do is, I guess, have an evidentiary hearing on the restitution and then decide if there's going to be a plea, but we can't really have, if the plea is contingent on you accepting restitution, then they're likely going to withdraw that offer if you're not agreeing to restitution. So if you want to have an evidentiary hearing to see exactly what the restitution is, I can do that.
Your Honor, my client will accept the restitution amount offered by the prosecution today and will enter her plea.
Okay, I'll take an advice.
Permission to approach. Your
Oh,
Honor.
yes, thank you. Okay, let's see. Let's raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury. Yes, okay, you can put your hand down. I do have an advice of rights and the information sheet. That's your signature. You've gone over these rights with Mr. Lee and you understand each of them. And so you're willing to waive or give up these rights today? And you understand that that means you give up your right to the presumption that you're innocent. So by right, you're innocent until proven guilty. You want to give that right up? You have the right to require the prosecutor to take this to jury trial and prove each element of the charge being brought against you beyond a reasonable doubt. The right to remain silent at any trial and not have silence be used against you, or you can waive silence and testify at your trial if you like. The right to subpoena witnesses that will testify on your behalf, and the right to cross-examine or question in court any witness called to testify against you. You understand that? Anyone threatening you to give all of these rights up? Any coercion or promises extended to you to get you to give up these rights? Are you currently on probation or on parole?
No.
Okay, you understand that by pleading guilty, it could result in a conviction that you might need to report to your current employer, or you may need to put that you have this conviction on a future job application. It also can have impact on where you can travel or get immigration status. So for example, you might want to go out the country somewhere on vacation and they could deny you entry into the country because you have a criminal conviction. You understand that? Okay, as to the amended charge of malicious destruction of property, 200 to 1,000. How do you plead? And that's a guilty plea with the understanding that the restitution is being sought in the amount of $5,195.03 that you agreed to, correct? Factual basis, counsel.
Thank you, Your Honor. Ms. Lewis, on or about December 17th, 2024, were you at the address of 530 Pacific Avenue?
Yes,
And that's in Lansing, Michigan, correct?
yes,
In Ingham County.
yes.
At that time, did you destroy or injure a 2018 Chevrolet Impala that was the property of India Marie Williams.
Yes.
And that resulted in damage that you will be paying restitution, on, correct?
Yes.
No further questions.
Questions for the prosecution?
Not gonna, Your Honor.
Court satisfied with the factual basis on the structure plea, I find your plea to be proved voluntarily and intelligently made. This matter is scheduled for sentencing October 30th at 1:30. When you leave here, you're gonna go down 1 floor to probation department so you can check in. They need to get a pre-sentence interview completed, so they're going to advise the court of how they believe you should be sentenced, okay? And you may appear for sentencing via Zoom, as long as you have video and you're in a place appropriate and prepared for court, okay? Do you have any questions at this time? Any additional matters for the record, counsel?
Nothing to that.
Thank you. You're all set. State of Michigan versus Floyd Rush 25-01911. Appearance, please.
Your Honor, Cassidy, could you just go people?
Morning, Your Honor. Yes, morning. Mr. Rush, at the council people.
Okay, this was a matter that was reset. This was preliminary examination. There was an assault, harm, and then there was a domestic violence third. We reset this because the defense wanted to see the surveillance from Pagano's. You received that, correct?
Did not, Your Honor.
How are we proceeding?
Your Honor, it's my understanding that the defendant intends to waive his right to preliminary examination at this time. That footage was not saved as it was already it was already lost because it was beyond the retention date for Python.
That was my understanding. Your Honor.
Okay, he does want to waive his exam.
Yes, Your Honor.
That is now.
It's after that one for sure.
There we go.
Yeah.
Yes, thank you. Okay. There was no offer at this time, is that accurate?
Not at this time, Your Honor.
There was no.
Okay, Mr. Rush, you understand your right to have a preliminary examination? Understand that it's your right to have the prosecutor establish that they have sufficient probable cause that the felonies alleged here were committed and there's sufficient probable cause to charge you as the individual who committed those felonies. You want to unconditionally waive those rights today by waiving your exam? Is anyone coercing you to do this?
No.
Any promises if you waive your exam? Your bind over date, which is the date the circuit court receives the file from this court, is September 10th. But your next court date is going to be a pre-trial, so your attorney will be made aware of that, okay? Do you have any questions at this time? On is set at 100,000 cash surety. There is a requirement for the defendant not to have contact directly or indirectly with the protected party and not to be within 2,000 feet of wherever the protected party is. Any additional matters for the record?
Not with you, Your Honor.
Well, yeah, that's found at this time. And the alleged victim did not show up today. He's willing and he was previously unbound and he did not, he has not violated the condition of his bond. Being in jail, he used to have a job. He was sentenced on his case in circuit court by Judge Stokes, and he's supposed to be released October 31st. So we would like the court to lower the bond to an amount that he can pay.
He's supposed to be released on October 31st. What was the sentence?
It was 180 days.
No, well, guess we'll have the court by then, that's filed by then, circuit court, and they can amend the bond if they want to. Bond will continue. Any additional matters?
Your Honor. Thank you.
Thank you. Let's see who we're gonna bring up next. Let's see. Is Mr. Palmer still in here?
Yes, Your Honor, I'm just hiding behind the computer.
Okay, do you want Mr. Cartel brought up?
Sure, if the court's ready for him, I am.
Okay, let's do that next, and then Mr. Lee.
He disappeared again.
I see. Who? I know. I know. He's on the record across the hall. I mean, did they just give Mr. Lee all the cases today, or what happened?
I think so. I'm not sure why, but it
Yeah.
appears that way.
He's in at least 3 courts at one time. And then, let's see. Yeah, well, everybody else is in custody. Or represented by Mr. Lee.
Your Honor, may Mr. Freeman and I approach on Arnold?
Okay, on the record in the matter of the state of Michigan versus Tajion Shannon, 25-02411, appearance, please.
Thank you, Your Honor. Cassidy Kachukis for the people.
Assistant Public Defender John Lee appearing on behalf of Tajon Shannon.
Okay, Mr. Shannon has a preliminary examination today on a weapons larceny. How are we proceeding?
Your Honor, it's my understanding that Mr. Shannon intends to waive his right to a preliminary exam at this time.
Was there an offer at all?
Let me double check. I do believe there was an offer.
And Mr. Lee, is that accurate that your client wants to waive?
That is accurate.
You can approach for the file.
Sorry, and it would be, the offer is, that there is a contingent thing on the waiver, it's consent to add in the felony firearm. But that the offer is that that consented added felony firearm would be dismissed upon plea of the First Circuit Court pre-trial.
We don't need the back. He's not pleading here, so,
Well, yes, but, oh, I guess the consent to add would be in circuit court.
yeah, they'll need it over there, but we don't need it now.
Permission to approach.
Yes, thank you.
No.
Okay, let's see, Mr. Shannon, you understand your right to have a preliminary examination in the district court?
Yeah.
You want to unconditionally waive that? That means that you're gonna give up your right to require the prosecutor to put forth evidence at this court to establish probable cause that a felony was committed and probable cause to charge you as the person who committed the felony. You understand that? Anyone threatening you to waive?
No.
Any promises if you waive?
No.
I know the date September 10th, that's the date circuit court received this file, not a court date for you, okay?
Okay.
Your next court date's gonna be a pretrial. Mr. Lee will be made aware of that day, and hopefully Mr. Lee won't be assigned to 95% of the public defender's caseload that day, so that he's not in 4 different courts at one time, okay? Do you have any questions? Your bond is set at 3,010%, and will continue. Any additional matters for the record?
Not gonna be the only.
Nothing for the defense. Thank you.
You're all set.
Don't wait for like.
We don't have any paperwork at this time, so you're good.
All right.
And then that's Mr. I'm sorry, Mr. Cartel. Okay, State of Michigan versus Jonathan Cartel 25-02435.
Your Honor, Cassidy Kachukis for the people.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Cartel, who is standing to my right.
Mr. Cartel was scheduled today for a preliminary examination on criminal sexual conduct in the 3rd degree and a domestic violence second. How are we proceeding?
Thank you, Your Honor. The people at this time are requesting an adjournment of this. We are still awaiting the SANE evaluation. And I had officers on call that I did not call in because of the request, because my understanding with counsel is that the preference would be to run this together versus start and continue. So I did not call those officers to come in. However, obviously, it's up to your discretion if you'd like to grant the adjournment.
Okay, so you still haven't gotten all of the medical records that you're saying?
Yes, Your Honor, this is a case that we are considering running victimless, but we would need the medical records to do so.
Okay, Mr. Palmer.
Thank you, Your Honor. I recognize this is not Mr. Kachukis, this is obviously the name wrong, but
That's correct.
I recognize it's not her fault, but I'm objecting to the adjournment. The issue is this: Mr. Cartel, excuse me, is sitting in custody both on this and on a hold from Judge Kennedy's Swift and Sure program as a result of this charge. So now he's sitting here in custody. There's an adjournment. Apparently, it would require, an adjournment would also require an adjournment of the swift and sure sanctions because they can't resolve that until, as I understand it, this case is the basis of the swift and sure sanctions. They can't resolve that until this case gets resolved. My issue, I guess, is that one, the complaining witness did not appear. I'm not sure, again, not the prosecutor's fault, but I'm not sure that the officers really collected a whole lot of pertinent information from her regarding contact information. Regardless, she's not appeared today. Additionally, if there's additional information that like we don't have, why, I don't know why we went ahead and charged immediately as opposed to waiting and getting all the information and then making a charging decision. So, you know, I know it's not time to argue facts of the case. The facts of the case are a little all over the place as well. So I have serious issues about the credibility of this witness. And with my client sitting in custody and entitled to a preliminary examination, I'm objecting to it.
Your
Did
Honor,
you want to respond?
if I may, yes. I can't respond to all of those concerns that defense counsel has. I believe it was charged with the intent that we would not be having to run a victim list. But that has since changed and we would need those medical reports to do so. However, the people would also are considering if we are unable to bind over on this at the preliminary exam to amending it down to domestic violence second offense and still running the trial victim list as a jury trial. So if the court would entertain it, we would ask that at the preliminary exam, if it be adjourned, that can be treated as the same as a final pretrial for a misdemeanor matter, so that it can just be set for jury trial after instead of being set for a final pretrial if we amend it down.
Okay, and to address your concerns, Mr. Palmer, I can't speak to what happened as to why this was charged and now we don't have a participating victim. I also recognize that it could be perceived as an inconvenience to your client that he's being held on a sanction for swift and sure or potential sanction because of this, but this is a very serious charge. This is a criminal sexual crime in the third degree. And simply because a victim has failed to appear or doesn't wish to participate, I don't know what it is at this point. We just know the victim is not here today. Is that correct?
I believe we don't have an address for the victim or a phone number for the victim, so the detective is trying to track her down.
Okay, so
And I
so
guess-
it's not that we don't have a victim that said that they're not going to participate or that was properly notified. It's that they don't know where to find the victim. But one thing I can say is I have an affidavit of probable cause in this file that is very detailed with facts, which we rarely get. And I'm bringing this up because you're talking about the court not relying, we don't know if we have a credible witness. This amount of detail as to what allegedly occurred is a lot, even for an affidavit of probable cause. The affidavit of probable cause is 2 pages long. And it details not just a sexual assault, but allegations of this alleged victim being held against her will for more than 1 day. And also abusive and possible drug-related activities that took place during this time. And so the officers allegedly transported themselves, this victim, to the hospital for a sane exam, to which all the prosecution is asking for is the result. This is something that happened allegedly 2 weeks ago.
That is my understanding, yes, Your Honor.
Judge, I understand. I'm not arguing with the court. My issue is that, for example, well, a couple of things. I haven't seen the affidavit, but what I would say is that the way the report reads and the way her statement on body camera reads is she's a little all over the place. That's what I'm talking about with regards to credibility. But the bigger issue for me is, as was just indicated, is that they took the time to take a report except there's no contact information whatsoever for the complaining witness. There's no address, there's no telephone number, there's no way to get in touch with her. There's no detective
Well,
assigned.
I agree, that sounds like sloppy work, but that can't be attributed to the victim. That's the.
Right, but it also can't be attributed to my client, right? Like, which,
Like, poor investigation or not properly detailing, if there is information that could be detailed to that regard, because the information I have in the affidavit of probable cause that she was living with the defendant at the time, or had been at the time of these alleged incidents. I don't know why they no longer have contact. All I do know is that these are very serious charges. Sounds like there's some efforts to move forward to make contact, but that at bare minimum, they're going to be moving forward victimless on a domestic for your client. And if I were to grant your request to dismiss this, and then they find or make contact with this victim, this is a reissued matter. Your client's got to get rearranged all over again, which is definitely not in the interest of judicial economy. So I'm going to deny any objection to adjourning this because they're asking for an adjournment so they can get medical records, not asking for an adjournment so they can find the victim. They can move forward victimless on these charges if they had time to get the medical records. And so with that being said, the case will be adjourned for good cause, and this matter will be set for a new date.
October 9th at 8:30.
October 9th at 8:30.
I just need to briefly correct something, Your Honor. There is a detective assigned to this matter.
Okay, I'm not sure, did he say there wasn't a detective?
That is what I think defense counsel understood. I don't know if there was one in discovery, but there is now a detective assigned.
Okay, sounds
got
good.
it. Fair enough.
Very good.
He had no way of knowing. I just wanted to make sure we were all on the
No,
same page.
no problem. Okay, so this matter will be reset until October 9th at 9:30. Bond was set at 65,000 cash surety with GPS tether and no contact with the victim. That will continue. Any additional matters for the record?
Not from the people, Your Honor.
No, no, thank you.
You're all set. Let's see. Oh, can you bring up Mr. Driggs?
Yes.
Okay. State of Michigan versus Charles Davis, 25-02436, appearance, please.
Cassie, could you for the people?
Assistant Public Defender John Lee on behalf of Charles Davis, who is present standing by.
Today was the date scheduled for Mr. Davis to have a preliminary examination on a motor vehicle unlawful driving away. There was also a domestic violence second in this file. How are we proceeding?
Your Honor, the complaining victim in this matter has not appeared, and our office has received a recant, and so I do not believe at this time that we will be able to proceed victimless, so I would expect a motion from the defense.
I'm sorry. There is a witness that failed to appear and your office received a recant?
That is correct, Your Honor, and that has been communicated to the defense counsel.
Okay, but your office is not going to withdraw the charges?
Uh,
There,
We have not had contact with the victim since then, so I don't know if we weren't able to look into whether or not it was a coerced statement. Or
Oh, if it's actual, oh, it was a.
if it was a we weren't able to investigate whether or not it was a coerced recant or an
Got
actual
it,
recant.
okay.
So I will leave the motion to the defense.
So you're not sure that, they've not been able to verify when it was a valid recant. Could have been anybody on the phone, is what you're saying.
That is correct. The name was stated, but we don't.
Got it. Counsel,
Your Honor, given that the state is unable to proceed, we make a motion for dismissal.
motion to dismiss is granted without prejudice. The people do have the right to reissue this against you. Do you understand that? Is that a yes?
Yes.
Okay, we'll get you a copy of dismissal in just a moment. You're on GPS tether. You need to go back down there so they can remove the tether, okay? You'll notify me. You have any questions? Any additional matters for the record?
Not going to be on.
Nothing for the defense, thank you.
He would like a copy of the dismissal. He should wait for a copy.
and turn off right here. I will. Clean to the 4 years of. Yeah. Same as we did for with Shannon, basically. I guess consent could be amendment, but then.
That wouldn't necessarily happen.
Well, you're not letting me finish. So that will happen in sugar.
This back tool, you gotta come up here by email.
Yes, to take the tether off. Yes, I think, or you probably could go straight to JSG too as well, but we will notify them that it can be removed.
Yeah, the amendment, so not the original charge.
To JSG?
I know it's on the Ingham County.
Not the original.
Ingham County, yeah.
So if we have to.
Right, it might just be easier to go back up there to have it removed,
And
Still go up there.
because I can't confirm if there's anyone at JSG
Agrees to add them.
to remove
That
it, but,
operator during the first free trial.
or what address they would remove it from if
I
it's
mean, the
at
felony
JSG.
was
So he should probably just go up to the Ingham County Jail where he
So
got it
the
put on and they can remove
Eventually,
it.
I'll go
Okay.
ahead.
And we'll
It's
send
just whether or not the
notification now.
offer preserved.
Okay, thank you.
You're welcome.
yeah, that's because I don't have the proofs for or 1,000 or 20,000. That's why we're
Amending.
going away, and then instead of just having them. I don't want to get up there and then
Right.
not have the right charges, you know.
Right, no, you're right about that. Okay.
We just haven't been able to run away.
Yeah, we've been.
It's standard. Everybody get help come down this always. Ain't no person.
Thank you. The probation department was transferring. It's free for all.
We'll be right back.
Very well.
On the record in the matter of the state of Michigan versus Travis Driggs, 25-02109, appearance, please.
Thank you, Your Honor. Cassidy, could you please put the key?
Public Defender John Lee appearing on behalf of Travis Lee Driggs.
Okay, Mr. Driggs is scheduled for a preliminary examination today. This is for larceny. Are we running this exam?
It's my understanding that the defendant intends to waive his right to a preliminary examination in this matter, contingent upon the amendment of the current charges. The current charge would have to be amended to, I guess you could dismiss the first charge and add to the correct charges should be one count of entry into a building without entry without breaking with intent to commit a larceny or felony therein. And a count of larceny from a building, and his offer in the matter that he's preserving with this waiver is that he would plead to the one count of larceny from a building, and the entry without breaking with intent to commit a larceny or felony therein would be dismissed. And I have the pack codes if the court would like those.
Do you want to amend count one to the entry without breaking with intent to commit larceny or felony? What's the pack code for that one?
The pack code is 750.111.
And then added count two is going to be larceny.
Larceny from a building, the pack code of 750.360.
And so wants to waive his examination with that understanding.
Yes, Your Honor.
I'm drawing it this time.
Permission to approach, Your Honor.
Thank you. Mr. Driggs can stand. Mr. Driggs, you understand your right in this matter to proceed to a preliminary examination because you are being charged with felony. You understand your right to have the prosecution first establish on the record here at the district court that they have sufficient probable cause that the felonies were committed and there's sufficient probable cause to charge you as the individual who committed the alleged felonies.
What is that?
You have the right to have the prosecution put forth evidence in the district court to establish they have sufficient probable cause that a felony was committed. Do you understand that?
Yes.
You also have the right to have them put forth evidence to establish that they have sufficient probable cause to charge you as the person who allegedly committed the felony. You understand that?
Charge me, yes.
Yes. And you wish to waive your right to have that hearing in this court?
Yes, ma'am.
Anyone coercing you to waive that right?
Yes.
Who's coercing you?
No coercion.
Okay. Any promises if you waive that right?
No.
Your bind over date is September 10th. That's the date that the circuit court receives the file from the district court. You do not have to appear in the circuit court on that date, okay? Your next court date will be a pre-trial. Your attorney will be made aware of that, okay?
Okay.
Is being held on something other than this?
Yes, I have a parole detainer currently, and I have 2 holds, one out of Clinton and one out of Clare County. That's why I was gonna try and ask the court today for a personal kindness bond, so I can start getting those matters taken care of while I'm waiting to go to court on this. Otherwise, it's gonna hold me in Am County jail, and I don't know if I'll ever be able to get sent over there on a writ or anything, you know what I mean?
You have a parole detainer and then you have a holds where?
Clinton and Clare. 2 different counties. Also, Clinton is for unpaid fines, and I believe Clare is the same thing.
Unpaid fine.
Unpaid fines because well, it's federal.
Well, those aren't serious.
No, Your Honor. He's looking for a reduction in bond and or a personal recognizance bond, so he can get out, start working, start getting his fines paid off. He's also got a hernia condition. that
I've also
he's
got
been dealing with.
it's health condition to deal with, yeah. It's actually sort of, you know.
Bond's only 3,010%. You want it lower than that?
Can't afford 3,000, 10%.
I haven't been able to work lately because of my hernia.
So then getting out, you're not gonna be able to work still.
Well, I'll be able to get my hernia taken care of, and then I can start from there. Well, I'm gonna get surgery while I'm in jail.
Okay, but you don't come to court.
I did come to court when I have the paperwork, and the only reason I didn't attend court last time was because I didn't receive the paperwork and the only thing I had for it. I don't have a good record then in attending court, but I do plan to try and get things taken care of.
So you don't have a. good
I don't have a
record
great
of what?
court record for showing court, no, man, but I do intend to.
Right.
In my life.
And then you got, that's why you got holds in other courts, because you're not taking care of
Well,
your
they're up
business.
north too, and I didn't.
Where do you live?
Currently I'm in Lansing.
Where?
Oops, I'm not sure the exact address.
That you don't know where you live?
I have a mailing address.
Nope.
I use.
Didn't ask you that.
I do know where I live. I live in
Where
Twin
do you-
Oaks apartment building. It's on Waverly and by John.
Where, yeah, I know where the
Apartment.
apartments are. Where do you live there?
I live with a friend of mine. I stay with a friend of mine.
Okay, so you have a friend that lives there,
Yes.
and that friend said it was okay for you to stay there, but you don't know the address or the
I
apartment number.
don't know the exact address. I do know the apartment number.
How
yes.
long have you been staying there?
6 months. I can't think of the address. I do know the address.
What's your phone number?
I currently don't have a phone. No. Not a number. Not a constant number that I've ever been reached at. No.
Really, since, how long has that been the case?
Since I was absconding on parole. Last year, probably.
So why did you give the magistrate a phone number last time? Or if you saw her?
Well, man,
Excuse me?
I give the magistrate a phone number last night, sorry.
So Magistrate Milmer just made a phone number up and a
Or she
mailing,
may have
and a
used
mail
that.
only address?
She may have used an old phone number.
No, she didn't.
What's the number?
How, she wrote mail only, what you just told me you can give me a mail only address, which means you gave her a mail only address,
Right,
correct?
I gave her a number.
And then she asked you what your phone number was after your arraignment, because that's a required question that we ask. And you told her a number.
I don't believe I did tell her a number. Not that I'm aware of. I don't have any number to give her. Why would I tell her a number?
Okay. So you don't know your address, you don't have a number to give her, you want me to lower the bond, and then you want your mail to go to someone else's address. Whose
No,
address is this, a
This
mail?
is a Advent House Ministries. I go there almost every day.
Okay, you want your,
I
so
have a
you gave-
caseworker there, Jack. I have a voucher there to try and get into a housing. There's a lot of different things I got going on that are good for me. I just gotta get them in order. You know, and when I was on the run of absconding, I wasn't able to do that because I was afraid of going back to jail, going back to prison. All because of some stuff that happened last year, you know, and now that this stuff's getting put behind me, I'd like to be able to try and make my life start going in the right positive direction again, you know what I mean?
I get it. Well, you're obviously know that you're not eligible for a personal recognizance bond. You do know that, correct?
Well, why is that?
Were you under court supervision or parole at the time of this alleged incident?
I was absconding.
That would make you ineligible for a personal recognizance bond. That, yes. You didn't know that?
I don't know.
Yeah, well, now you know. If you're already on probation or parole, and then you pick up a new case, then that gives the presumption that you're not gonna follow court order. So that makes you no longer a candidate for a personal recognizance bond, which is why she gave you a bond of 3,000, 10%. I can lower it, but I will not give you a personal recognizance bond. I will amend your bond to 2,000, 10%.
I'm gonna have to send Rich then to these other counties to try and get this taken care of. I don't know how to build on all. That's not gonna.
Correct. You can send bonds or communications if they want to write you, then that's up to them. If it's for fines and costs, it's not likely that they're going to do that. Because it costs taxpayer money to do that, to try to collect money from you that you obviously don't have at this time. So that one, I think your parole hold is probably primary right now, more than anything else, but it'll get taken care of, I'm sure.
Okay. Another thing is like, the burden of proof on this case is, there is none. I didn't do this crime.
No, the burden of proof, there's definitely a burden of proof. There's always a burden of proof. They have to prove each element beyond a reasonable doubt.
Yeah,
So maybe what you mean, the evidence.
yeah, they
There's
don't
no
have
evidence.
There is no evidence.
Okay, I don't know, because I'm not here to hear evidence on this
But
case.
honestly, I think which crime. so.
Okay, well, you are maintaining your innocence, and that's why a not guilty plea has been entered on your behalf. So this matter will continue to trial unless you change your mind about your innocence. And so until then, the matter is just going to be processed now, getting prepared for a trial date. Okay.
Okay.
Do you have any other questions, sir? Any additional matters for the record?
Not for the people, Your Honor.
Not for the defense, thank you.
Thank you. You're all set.
Okay, copy of pictures of.
I have them.
Okay.